Islam, peace and love, peace, love, and energy, energy, energy. I am Sade Renee L, all rights reserved, and I'm back at it again with another video. And today I'm actually just going to be doing a quick video about case law, and just going to get straight to it. Thank you for your time. Please like, share, subscribe. And it reads as follows. So let's go over Kangaroo Court. Last time I made a special appearance, it was actually very funny. Somebody screamed out Kangaroo Court. So I wanted to touch bases on this because this is a real thing. So Kangaroo Court, it's a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded and in which the result is a foregone conclusion because of the bias of the court or the other tribunal. Okay, and that's Black Law's Dictionary. That's the 6th edition, page 868, which is consistent with the fact that everything they do is fraud under the color of law and is the appearance of justice only. Emphasis added. In as so much as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible, The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate, artificial persons and the contracts between them. And that's Penhallow versus Dones Administrators. You can look it up. There is no such thing as power of inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, we the people. And Congress can exercise no power which they have not by their constitution entrusted to it. All else is withheld. That's Juilliard versus Greenman. Look it up. All right, let me scroll down a little bit. All right. And it reads, governments are but trustees acting under derived authority and have no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. I'll repeat, very important. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. Very important. Write it down. That's Luther versus Borden. All right. Scrolling down, this has a little to do with statutes more so. No one is bound to obey an unconstitutional law and no courts are bound to enforce it. Now that's 16th American Jurisprudence, 2nd edition, looks like, or 2D, section 177. Again, look it up. An officer who acts in violation of the Constitution ceases to represent the government. That's Brookfield Co. versus Stewart. All right. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency. Okay, it's all fraud, they all work together, but only in a ministerial and not a discretionary capacity. That's Thompson versus Smith. Very important, write it down. Trying to scroll down. All right, scrolling down. Ignorance of the law does not excuse misconduct in anyone, least of all in a sworn officer of the law. Very important, write it down. Henry McCowan, 1917. It is one of the fundamental maxims of the common law that ignorance of the law is excuses no one. Again, ignorance of the law is no excuse. And that one is Daniels versus Dean. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency. That's K.C. Davis, Admin Law, Chapter 1. It is the accepted rule, not only in state courts, but of federal courts as well, that when a judge is enforcing administrative law, they are described as mere extensions of the administrative agency for superior reviewing purposes as a ministerial clerk for an agency. That's 30 CAL 596. All right. Where any state proceeds against a private individual in a judicial forum, it is well settled that the state, county, municipality, etc., waives any immunity to counters, cross claims, and complaints by direct or collateral means regarding the matters involved. That's Luckenbach versus the Tekla, and also Lighters versus Lund. Scrolling down. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. See Owen versus City, and also both that Terry. Owen versus City 445 US 662, both that Terry. I wanted to touch bases on that too, because people always think that like the policy enforcers or even like the CPS or the CFS agency has immunity. These people do not have immunity, as clearly stated right here. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. That goes for their agents as well, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. That's Thompson versus Smith once again. All right. And we're going to end it with immunity for judges does not extend to acts which are clearly outside of their jurisdiction. And as you can see, that is several court cases to back that up. All right. And again, like I said, I was just going to do a quick video in regards to some case laws I just want to share. Again, write it down. Other than that, I'll be back at it again with another video. So please like, share, subscribe, go ahead and donate. And until next time, free baby Ashe, high vibes only, peace and love.